Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Hello, Peter. Nice to see you
Hi,
again.
Trevor. Yeah, you too.
Yeah, so very chilly in wet and cold and misty in the Cape where I am, and I think in many other parts of the country as well.
As it should be. It's winter.
Indeed. Let's not. We've got other things to talk about than the weather. Right. We'll start off discussing the Capitec case. That's the judgment of Judge Rogers in the Constitutional Court. And, I was aware that the case had been argued in the Constitutional Court, and the judgment seemed to be taking an inordinate amount of time. But when we got Judge Rogers's judgment, he starts as follows. The writing of this judgment was assigned to me following the unfortunate indisposition of our colleague Van Zyl AJ, who was present at the hearing but was to have written the judgment. The court expresses its regret for any resultant delay this has caused. So that's the explanation why it took so long. The facts were that Capitec went to the tax court, won its case 100-0. Went to the SARS appeal to the Supreme Court of Appeal. Capitec lost 100-0. And they appealed to the Constitutional Court, and this is the result. And in my opinion, this is a very welcome judgment because although I disagree with the ultimate finding, a lot of things that I think were unclear from other judgments have been very nicely clarified by Judge Rogers, and well done to him for that. The facts were that Capitec took out an insurance policy with an insurer, and it then certain of its borrowers, it undertook that if they were either retrenched or died with certain amounts owing, Capitec would take care of that. And obviously the other insurance policy was in the background to assist with that. And it was expressly said in the agreement with the borrowers that Capitec did not charge for this insurance benefit. And the court accepted that. So let me just go through some of the findings of the court. The Constitutional Court always has to decide whether it has jurisdiction in the matter, because although it's the apex court, they don't just decide any old matter. And often you apply for leave to appeal, but the actual hearing and the leave to appeal is decided in one judgment. And he said that the following 4 points indicated that the matter should be heard by the Constitutional Court. Firstly, the correct VAT characterization of suppliers made free of charge. And in my opinion, that's been one of the vexed issues ever since VAT came in 1991. Secondly, the legal significance, if any, of the fact that unpaid fees, the earning of which would ordinarily be an enterprise activity, had been capitalized. Because the Supreme Court of Appeal had said, well, then that made it credit as opposed to fees for services. Thirdly, the proper interpretation of section 16(3)(c) of the Act, which is what this case was all about. And then fourthly, whether apportionment in any form was available in such circumstances. And before I go any further, I think one must, Judge Rogers is primus inter pares, first amongst equals. For I have the highest respect for him. There's no one for whom I have higher respect than him. So whatever I say must be seen in that light. But I do differ with his ultimate conclusion. But remember, he was giving a judgment on behalf of a full bench of, I think, 9 judges, although Van Zyl had dropped out of the picture. And I'm not sure what the dynamics of that are, but I imagine the judges get together afterwards and they decide more or less which way the judgment should go and assign somebody to write it. And obviously that person changed to Judge Rogers, as we've already said. And presumably there's some sort of the judge writing the judgment must give effect to the feeling at that meeting where all the judges were present. Anyway, I'm hazarding a guess. I'm not sure. Anyway, the first myth that was exploded is that the court held that Capitec's supply of loan cover was not disqualified from being a taxable supply merely because it was charged free of charge, because it was supplied free of charge. The Supreme Court of Appeal had held that disqualified it, and he held that the SCA had erred in finding otherwise. And he explained it as follows. A taxable supply was a supply as contemplated in section 7(1)(a), which is the charging section, which was the supply by a vendor of goods or services, quote, in the course or furtherance of any enterprise carried on by the vendor. That's the requirement. Section 7(1)(a) did not impose a requirement that the supply had to be for consideration. In order, however, for the supply to fall within the scope of section 7(1)(a), it had to be supplied in the course or furtherance of an enterprise. And of course, the enterprise would require the charging of consideration, but not necessarily on every single transaction. So he said the definition of enterprise required that the enterprise or activity had to be carried on continuously or regularly, and had to be one in the course or furtherance of which goods or services were supplied to another person for a consideration, whether or not for a profit. Did not require that all the goods or services supplied in the course of that activity must be supplied for a consideration. The requirement was that the activity must be one in which the goods or services were supplied for a consideration. The activity. And he gave various examples of merchants selling a loss leader in order to get feet into the shop and all that sort of thing. In relation to section 1023 of the VAT Act, he said that section made clear that any supply, whether taxable or non-taxable, could be a supply for no consideration, in which case it was to be assigned a value of nil for any purposes relevant to the Act. The court dismissed what the Supreme Court of Appeal had held, namely that where fees are not paid when initially charged but are capitalized, that amounts to the granting of credit, which of course is an exempt supply as distinct from the charging of a fee, which is a taxable supply. And Judge Rogers said he obviously didn't express himself like this, but he said that's absolute nonsense. And I think you and I, when we discussed the SCA judge, we agreed with that. So good for him. But he pointed out that all the law governing the in duplum rule would be nonsense if when fees were capitalized, they ceased to be fees. And because then by the same token, interest would cease to be interest as well. And he cited some authorities in that regard. So I think he dealt with a number of things that the Supreme Court of Appeal got wrong. But then he went on to deal with apportionment. And he found that the amount claimed ought to have been apportioned because it was partly in the pursuance of a taxable activity and partly not. And he quoted cases like Nemegem and other where in Nemegem, Judge Corbett had said apportionment it gives one a sense of fairness from both the point of view of the fiscus and from the point of view of the taxpayer. The sort of fireside chat, sort of warm sort of feelings, which is all very well, but it's got to be appropriate. And the court held that an apportionment of the sections 16.3c deduction was a practical solution. He also pointed out that a section 16.3 deduction is not input tax. It's a special deduction with its own provisions, and I've got it here. An amount equal to the tax fraction of any payment made during the tax period by the vendor to indemnify any person in terms of a contract of insurance. And he did point out that it was not in dispute that there was a contract of insurance. So the court wasn't called upon to decide that. But the matter was argued on the basis that it was a contract of insurance. So you're entitled to deduct the tax fraction of any payment made during the tax period to indemnify another person in terms of a contract of insurance. And then it says, provided this paragraph shall only apply where the supply of that contract of insurance is a taxable supply. And here's where I think he went wrong. Something is surely either a taxable supply or it's not a taxable supply. I mean, you can't be half pregnant. You're either pregnant or you're not pregnant. In this instance here, it either was a taxable supply or it wasn't a taxable supply. And his own reasoning in saying that you can a taxable supply can be for no consideration. He pointed out that whether something is a taxable supply has got nothing to do with whether there's consideration or not. It's a separate test, as long as it's part of an enterprise. So if the test were that it must be in the course of an enterprise, then I could understand an apportionment. But here it was in the case of a taxable supply. If one imagines a fact that, let's say that the bank was charging for this insurance cover provided to its clients, would that have been a taxable supply? I think it's clear that it would have been. That they would have had to charge VAT, and if that happens, then it's clear that it's 100% a taxable supply, or it's not a taxable supply, but it can't be half and half. Anyway, he went on to say that an apportionment was appropriate, and then curiously, he said it would seem that the court was alive to this difficulty, which explains why I suggested, I'm saying this, these are my words. It would seem that the court was alive to this difficulty, which explains why I suggested that Section 72(1) of the Act could perhaps be called in aid to support this approach. Section 71 applies where there are anomalies and gives SARS the power to resolve anomalous situations. But it has to be done in such a way that doesn't result in more or less tax. But the very fact that Judge Rogers was suggesting that because the matter was referred back to SARS, that they could act in terms of Section 72, suggests to me that he had some I won't call it uncertainty, but unease about the direction of his judgment right at the end. That's how I read it. But actually, I don't think Section 72 could be used, because if you did, then it alters, either the amount is fully deductible or it's not deductible at all, as I see it. And you can't use Section 72 for anomalous situations to make it partly deductible.
Interesting.
Okay. So that's the upshot. It'll be interesting to see how that ultimate decision of the court, whether that spills over into other situations, because there will be other situations where, in relation to input tax, something might be done for no consideration, but still be part of an enterprise. So it is a taxable supply, but there might be an issue of apportionment. So on the whole, I think an excellent judgment, but I think went slightly astray right at the end.
Would you score that? How would you score that, Trevor? 2 goals each, or because you said 100-0 in the tax court and 100-0 in the SCA. So this is what, a 50-50.
I think it appears from what he said, because the judge said that an apportionment would be very easy, because take the amount of interest income and the amount of fees. But I think it's not. This was transactional banking, or I'm not sure of my terminology here, but this was only one segment of the business. If you take the other segment, another segment of the business, then the fee element is much, much larger. So it could be more like 50-50 than 12%. That was what he mentioned. So we'll see. So it's going back to SARS, and I'm not involved, but
interesting judgment there. And interesting how apportionment is sort of pulled then from the income tax provisions into the VAT Act in terms of this case. And interesting how you referred to income tax cases like Nemagen. And apportionment obviously forms a big part of the income tax analysis. You've got things like capital revenue where there's sort of no halfway house, but you've got apportionment of expenses. Nemagen was a good example, dealing with share trading. And it also, that formula came up with a very practical, kind of pragmatic solution, the Nemagen one I'm talking about. And then you even got, potential apportionment in respect of source of income issues. And that's sort of open for debate a little bit, but whether something like tax case allows you to apportion source income between source locations. So I think apportionment is generally, it's a very fair fallback position, Trevor, throughout sort of, the Income Tax Act. And interesting how it's now, as I say, sort of found a home in the Capitec case. And the judgment that a reasonable apportionment was mandated by the VAT Act. It leaves you with a sense of fairness.
I agree. But it's a fuzzy, warm feeling. But I'm not sure because the real issue was it a taxable supply, and the court itself said you don't have to have consideration in order for it to be a taxable supply.
It's a very interesting point.
Just imagine if they charged for it, it would have been plus VAT in its.
And I see Capitec didn't plead the partial deductions. They didn't plead apportionment as an alternative. And the courts overlooked that, but didn't penalize them for that. It said in terms they should not be penalized for its failure to do so. SARS should not seek to exact a tax which is not due and payable. So that was also quite interesting and sort of forgiving and permissive, I suppose.
And that almost picks up on what was decided in the Free State Development Corporation case. That SARS mustn't, as you've just said, SARS as an organ of the state subject to the Constitution mustn't exact tax. Now, the way I see that, I mean, I agree 100%. I'm sure you do too. But how do you decide that? If you've got, I mean, the Free State Development case was involving an amendment to a pleading. But let's say you put something in your pleading which wasn't in your objection, and you say that if we're not allowed to argue this, and I've been involved in two matters where this is very much a live issue. Now we applied for leave to appeal to the SCO, and I believe it or not. If the court says, no, you can't argue it, how can they decide whether or not SARS would be collecting VAT in circumstances where it's not allowed to collect VAT if they don't look at it? Anyway, let's not get overly distracted on that. But I think that's a very important and a very welcome aspect of the judgment.
The other interesting thing, Trevor, because so many court cases and tax court cases are going from the SCA up to the Constitutional Court, and the point that you alluded to right at the start is that is far from a slam dunk. Because in order to get to the Constitutional Court, you need to either have a constitutional point, which is very rarely the case in tax law, or the application or the case must involve an arguable point of law of general public importance, which ought to be considered by the Constitutional Court. And that's quite a high hurdle. And it must be in the interest of justice to grant leave to appeal. And the Constitutional Court must think that you have reasonable prospects of success as well. So your first part of that hearing, because as you said, it's a very strange hearing in the Constitutional Court, because you're applying for leave to appeal and you're arguing the merits in the same day. and you can get biffed on the first part and not get to the second part, but the first part is not a slam dunk, and it's a very high bar and a very high hurdle. I think the Constitutional Court have been quite good in that regard, in the sense of bending over backwards, is maybe putting it a bit strongly. But I think they've granted leave to appeal in quite a lot of tax cases where they could have gone the other way and said, you know what, we don't think that this is general public importance, or we don't think it's an arguable point of law, or we don't think you've got reasonable prospects of success. Maybe there's some facts involved. But they've been very good with that, and I think it's really, really great for us as tax practitioners.
There is a case, I think it's called Sassel Chevron, also in the Constitutional Court, where the court held that the manner in which tax is collected is a matter of general public interest. Which so that's obviously. And of course, there's two other tax cases where we're awaiting judgment. The one is the Thistle Trust.
So
the other is, of course, Coronation.
Coronation, absolutely. And the Section 105 cases that we've talked about in previous podcasts are also lined up to go to the Constitutional Court, at least 3 of them. And they were, in fact, going to be heard over the time of the election, so last week. And then because there was a concern that there might need to be urgent applications brought to the Constitutional Court last week, those were pushed out. So they now, I don't know when the date's set, but it's in a month or two's time. So unfortunately, our very important tax Section 105 of the TAA cases have not yet been heard by the Constitutional Court. So we're going to need to wait for that one.
Yeah. Judge Rogers is on long leave at the moment, and he told me he was disappointed that he would be missing that case, but maybe he'll just make it back in time. Delayed here. But the impression I got from that, he was aware of it, was
interesting.
They certainly will get leave.
But
there are 3 cases, and that obviously is of critical importance.
It's of great importance, yeah, and to put that issue to bed. So, Trevor, I also want to talk a little bit about the anti-tax avoidance provisions, GAAR as we refer to it. And as you know, before SARS can issue an assessment using GAAR, they need to issue what's called a Section 80J notice, because it's in terms of Section 80J of the Income Tax Act. And that basically means that the commissioner must give the relevant taxpayer notice of his intention to use the GAAR provisions, to invoke the anti-tax avoidance provisions. And the taxpayer then has 60 days to submit reasons why the GAAR provisions should not apply. And then the commissioner then has 180 days after receipt of those reasons from the taxpayer to either request additional information, withdraw the notice, or determine the liability of the taxpayer using the GAAR provisions. And part of the reason that Section 80J exists is because the GAAR provisions are so draconian. If you look at Section 80B, the powers of the commissioner are really enormous in terms of where GAAR is invoked, and disregard transactions, disregard taxpayers, recharacterize amounts, and really has very, very wide powers in terms of Section 80B. And I think that's why the Section 80J notice is so important.
They're almost imposing a fiction.
Exactly.
The way in which you've done that, we're going to consider it to be a different transaction.
100%, exactly. So we had an interesting case recently where our client got a Section 80J notice, and the Section 80J notice from SARS was based on the wrong facts. They just got the facts wrong. They didn't describe the transaction steps correctly or accurately. So our client wrote back, and we wrote back on behalf of our client and said to SARS, you've got the facts wrong. These are the true facts. This is really what happened. These are the transaction steps. And then we didn't stop there. We then said, and these are why the transactions were entered into. And said that the GAAR provisions did not apply to the facts as they stood, the true facts. SARS then ignored our response and went ahead and assessed on the basis of its incorrect understanding of the facts, which we thought was quite unusual that it didn't interrogate further. It didn't sort of say, hang on, we think it's X, you've said it's Y, let's have a debate around that, or produce evidence or give information or whatever. It went ahead and assessed on the basis of the incorrect facts. So then we objected, and SARS disallowed the objection, and then we got into the pleading stage. And I think possibly at the pleading stage, you end up involving counsel maybe, and maybe some external party, etc. And then, so the Rule 31 from SARS, the start of their pleading phase, came along to our client, and it acknowledged that it had previously got the facts wrong, and it raised the GAAR provisions, or applied the GAAR provisions through the Rule 31 statement on the correct facts. And we said, hang on, there's a Section 80J, that you seem to be forgetting about. You can't assess us through a Rule 31 statement. You need to start again, start your process again. Give our client a chance to respond to your Section 80J notice on the correct facts, so we can respond to you on that, and you can consider whether or not an assessment is appropriate. And if it is appropriate, then you can assess, and off we go again. And SARS were having none of that. So we went off to the tax court using the High Court rules, I think it was Rule 30, to strike out SARS's Rule 31 as an irregular step, for the reasons that I've just said. And SARS tried to argue that in terms of Section 80J4, if new information came to hand, then they can sort of alter their assessment. And we said, well, new information didn't come to hand, firstly. Secondly, if there was any new information, it came to you before the assessment. And, so that provision just wasn't relevant. 80J4 wasn't relevant. So we went off to the tax court, and Judge Meyerberg has just released a reportable judgment, basically finding in favor of our client and striking out the Rule 31 statement of SARS. Quite interesting to see, sort of a combination of points there, I suppose. One is how you can use the High Court rules where there's no appropriate tax court rule, that the tax court does find in favor of taxpayers. It's not a one-way street, some people have been saying for the last year. And I thought a very, very good, very clear judgment, and a very fair judgment. And obviously, I'm not objective. We acted in this matter. But again, SARS, arguing that they were left remedyless, but that's not the case, because they can always start their processes again, painful though it may be, and sort of go through the proper process of the Section 80J notice and giving our client a chance to respond to that. So quite an interesting judgment that will be released in sort of redacted form, obviously tax court, so client confidentiality applies. But I thought a very interesting judgment, and I think you said you had something along vaguely similar lines at some point.
Had a similar thing. It wasn't that the court got the facts wrong, but in a 80J notice, they'd used a certain reasoning to say that something was taxable. And then our case was that in the Rule 31 statement, they changed that. And we said, you can't change it. Because this is taxation by SARS as diktat effectively, that is the assessment, and you've got to stick to it. And there's an old case where Judge Rogers, just purely coincidental, Judge Rogers, when he was still at the bar, I can call him Owen for that purpose, he acted uncharacteristically for the taxpayer. I think it was one of the companies in the Rembrandt group, and he took this point, and he won it on that point in front of Judge Desai. And then there was another case subsequent to that, where in fact, I acted in that one, where we relied on Judge Desai's judgment, and Judge Rogers was on the bench. And of course, he accepted what Desai had held, knowing full well that it was more or less a version, word for word, his own heads of argument. But I mean, it's a very good and important point. And we were unsuccessful, so that's why I'm really impressed. I'm glad to hear that. Because the judge said, no, that decision of Rogers J was under the earlier provisions, section 1034 of the Income Tax Act. This is now the Tax Administration Act, and it's different. And I don't think it is different. I mean, obviously the wording is different, but the principle is. I'm very
Rule
pleased.
31. Good result. And the Rule 31 statement.
There's hope for the taxpayer after all.
Hope for the taxpayer, because the Rule 31 statement can't be a novation of previous arguments. And it also can't be issued in circumstances that require the issuance of a new assessment.
Yeah.
And I think that was the point here, that the judge held. No, hang on, you actually do need to issue a new assessment because Section 80J notice needs to be given and you need to go and restart your processes. So your Rule 31 amendments lead to the requirement that you issue a new assessment, and therefore I'm going to strike it down as an irregular step. So that was quite a
wonder if they'll do it.
Good argument.
I wonder if SARS will.
Yeah. It'll be very interesting to see. And
you can raise the point that you're being subjected to a tyranny of litigation.
The other interesting case that I think is in front of the courts as we speak, if not, it starts very soon, is, can you believe it, a GAAR matter going to the tax court. We've only waited since 2006, the new GAAR, can't call them new GAAR provisions, goodness, 2006. But there's no reported case on GAAR, and apparently a case is being heard now. So I'm still a bit of a cynic, Trevor. I still think at some point somebody will settle prior to the end of the proceedings. But wouldn't it be nice to get case law on this question finally of whether purpose, the sole and main purpose test, is a subjective test, which you and I believe, or whether it's an objective test, which seems to be SARS's position, has consistently been argued by SARS, that it's objective or more objective. And it would be really nice to get a bit of law, albeit from the tax court, on that aspect. So here's hoping.
I think in the ABSA Bank case in the Supreme Court of Appeal, I can't remember the judge's name, but he more or less held it was a subjective test. And they was criticized by our fellow editor, retired Judge Davis, for that, but I took him to task. It's obvious subject.
How purpose not always
be objective?
It's a subjective question of fact.
To take into account in order to determine the purpose, but it's always a subjective thing.
An arrangement cannot have a purpose, as I say. A taxpayer can have a purpose, but an arrangement can't. But that we will, again, we'll keep our viewers up to date on that, but it'll be really great to get a bit of case on that aspect alone. So here's hoping.
I must say, it took me about at least 10 years to start using the word GAAR. I always found it a bit odd. Now I like it. So I'll give GAAR litigation.
Excellent. Trevor, nice to catch up again, and I'm glad we didn't have such a long wait, and let's do it again sooner rather than later.
Fantastic. Nice to see you again.
Yeah, thanks, Trevor.
Thank you to our listeners. We do get occasional bit of positive feedback, and it's always nice to hear. And we don't take it for granted.
Cheers.
Thanks.
Bye. Bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.